What happens if I ignore a winding up petition? Well, first of all, don't do that. It's probably the worst thing you can do, is putting your head in the sand. It's a very serious legal matter if your company's been served with a winding up petition, so you should take it seriously and seek advice from someone like myself, a licensed insolvency practitioner. Because there's serious ramifications if a winding up petition is ignored. And even if the petition has been served on the company, there are still options available to you and to the company. It doesn't have to mean that you stop trading. There are lots of things that we can do, but you have to consult with someone like myself so we can run through what the options are. Ignoring it just makes it worse, and if you do ignore it, chances are the company would get wound up, it'll stop trading and it'll be a bit of a disaster, so don't ignore it. But essentially, when the petition is served and before the hearing date, so this isn't even at the hearing, it can be advertised in the London Gazette. So it becomes public knowledge that there's a winding up petition against the company. And as I said, it's a very serious matter and it does cost creditors quite a substantial amount of money to actually pursue. So they're obviously serious in what they're doing to take that action. It's not done lightly. So, other people will know this because it's in the public domain. Suppliers might be aware that there's this petition outstanding and they might stop supplying you. I mean, they're going to see the business as risky if there's an outstanding winding up petition. They're not going to put themselves in a vulnerable position, so they might stop supplying you. Other creditors might be aware of it, and if they've got outstanding invoices, they're going to be worried about what's going to happen, so they're going to ramp up the pressure to make sure that the company pays their outstanding invoices. They might even piggyback the winding up action. So once it's in the public domain, the pressure builds on the director, and people try to protect their own position, including the company bank. So quite commonly the banks routinely monitor the London Gazette for notices just like this of a winding up petition, and once they're aware of it, they will protect themselves and they will freeze the company bank account. And you can't trade when you don't have a bank account. It's very serious, and that's even before the hearing. So if you are ignoring the winding up petition and thinking you'll just wait until the hearing, you need to be aware that things happen way before then, that it does get advertised in the London Gazette, becomes public knowledge. Suppliers, other creditors, the bank will take action to protect themselves. And also, once the petition's been served, and if the winding up order goes through, any payments that you made in that period might be at risk, even if they're just normal trading payments. They can be at risk, and it would take a court order, so essentially a judge providing a validation order saying that the payments are okay and don't need to be reversed. So any payments that you're making, even if you think they are legitimate and just normal part of trading, you might be paying suppliers, creditors, employees, yourself, they might be at risk. And also what you shouldn't be doing during this time is selling any assets. So you have a duty as a director to make sure that you're protecting the company's position, including its assets, so don't sell any assets. You need to take advice in that regard. So it's a very, very difficult time. The pressure is on and your conduct will be looked at during this time. So it's absolutely vital that you seek advice from someone like myself so I can advise you what you can and can't do. And as I said at the beginning, there are other options. It doesn't mean the end. It doesn't mean that it has to go into compulsory liquidation. There are things that we can do before then, but you have to seek advice. We have to be able to help you. And even if there's nothing we can do, or you're assigned to the fact that the company's going to go into liquidation and it's going to have to stop trading and it'll be wound up through the courts, you still should take advice so we can advise you personally as a director as to what you can and can't do. because you don't want anything to happen to you personally. You know, the ramifications of doing something incorrect could be costly. You might end up owing money back into the estate, or you could be disqualified or anything else. So it is a tricky time. So what I would say is, if there's been a winding up petition presented at the company, or someone's even threatening it, or you think one might have been filed but you've not yet been served on it, anything like that, you need to get in touch with someone like myself so we can help you and help the company and advise you. It is so important. It's a serious legal position that the company's in, so it's always best to take advice. So if you're worried that a creditor's going to wind you up, or a petition has been served on you, or you think it's going to be served imminently, get in touch with someone like myself. So if you head to Park Walsh, all our contact details on there, and you can book a consultant. It's free, no obligation, etc. So get in touch. Okay, thank you.